Recording in progress.
Iku Iluna, please rise. Auhea o ko eko ka aha, nahe kuliana imo o kea aha. O kolo kolo ki ike hano hano o kamaku aina o Hawaii. E nawe mai, e malio mai, I lohe ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Enoho ilavu. Please be seated.
Please call the case.
Case number SCCQ-23-0000515. ALOHA Petroleum Limited versus National Union Fire Insurance Company of Pittsburgh, Pennsylvania, and American Home Assurance Company. Arguing for plaintiff appellant ALOHA Petroleum Limited, John Sylvester. Also appearing Michael Hare and Michi Momose. Arguing for defendants appellees, National Union Fire Insurance Company of Pittsburgh, Pennsylvania, and American Home Assurance Company, Christopher St. Ginos. Also appearing Terrence O'Toole and Kerry Noborikawa. Argument on the merits.
All right. Good morning. Aloha, everyone. Today's proceedings being broadcast live on our YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? All right. Okay, we've allocated 30 minutes for each side. Mr. Sylvester, you'll have 23 minutes. We'll give you a warning light at that point. You've reserved 7 minutes for rebuttal, is my understanding. Mr. Ginos, you'll have 30 minutes, and we'll give you a warning with 5 minutes to go. Mr. Sylvester, if you're ready, please proceed.
Good morning, Mr. Chief Justice, Associate Justices of the Supreme Court. My name is John Sylvester of the Kano Gates Law Firm, counsel for ALOHA Petroleum. In this case, ALOHA Petroleum seeks to avoid their duty to defend ALOHA Petroleum in the climate lawsuits because the underlying plaintiffs have alleged, among other claims, reckless behavior on the part of ALOHA and other defendants. AIG's refusal to defend ALOHA runs directly contrary to this court's prior decision in Tri-S versus Western World Insurance Company in 2006, which specifically held that recklessness can constitute an accident and therefore can constitute an occurrence in a liability policy. I should say, if AIG's position in this case were adopted, it would dramatically reduce liability insurance coverage for both businesses and residents in Hawaii who are simply alleged by the plaintiff in a case against them to have acted recklessly as well as negligently. I'm sure that this court is familiar with the background of the case, and so in the interest of time, I'll just go directly to the 2 certified questions from the Federal District Court. The first of which, as characterized by Judge Otake, was for an insurance policy defining a covered occurrence in part as an accident, can an accident include recklessness? The answer is simply yes. This court has already decided that in the Tri-S case. And I should add, and I'll get to it in a moment, that the older Supreme Court cases that AIG relies on to oppose that position are not in conflict with Tri-S, but easily reconciled with the Tri-S decision. Occurrence in the context of a liability policy, such as the 12 liability policies that AIG issued to ALOHA Petroleum over the years, define occurrences as an accident, including a continuous repeated exposure to conditions. And that is, the focus, of course, is on the word accident. And there are allegations in the underlying climate lawsuits of recklessness in the sense of the plaintiffs are trying to make out, in addition to claims of negligence and other products liability claims, they're trying to make a claim for punitive damages. And so they allege that defendants acted with malice, with actual malice. They say that the defendants acted with conscious disregard for the probable dangerous consequences of their conduct and the product's foreseeable impact on the rights of others. But specifically and importantly, there are no allegations in the underlying climate lawsuits that ALOHA or the defendants intended to injure or harm the plaintiffs. And that is the significant factor that takes it out of the older cases, Kerrang and Brooks and Blanco, and even the Hawaiian macadamia nut case, which I'll discuss in a moment. But in the absence of any allegations of a specific intent to injure or to harm, that type of recklessness can constitute an accident, as has been held by this court in the Trias decision. The Trias case, as you'll recall, involved a wrongful death suit where a worker was electrocuted when his drill rig struck a high voltage power line, and he sued, or at least his heirs sued both the company and Mr. Taft, who was the owner of the company, and made allegations of willful, wanton misconduct and recklessness for failing to enact.
Counsel, I'm sorry. Can I ask you a quick question on this area? Can a person engage in reckless conduct but not expect an injury to happen or think it's practically certain an injury is going to occur?
Yes. For example, the most common example, somebody driving at an excessive rate of speed down the highway. They're driving 90 miles an hour. They're driving recklessly, but they're not intending to crash into anybody. In fact, they're intending not to crash into anybody. But oftentimes, although it's reasonably foreseeable that they may crash into somebody, it happens that does in fact take place. And in that case, insurance coverage, liability insurance coverage should cover that. Now, if AIG had their way, there'd be no coverage for that circumstance. If somebody's speeding and they end up, in an accident because of driving at an excessive rate of speed, that would put Hawaii, if that were adopted by this court, in a dramatically minority position with courts all around the country that recognize specifically recklessness as potentially an accident and an occurrence in a liability policy.
Counsel?
Sorry, yes.
Please go ahead. Follow up.
Go ahead, Justice.
I'm kind of switching gears. I'm trying to think this through. If we were to answer yes to question 1 and yes to question 2, would that be determinative of the cause in federal court?
Well, if we're talking now about the pollution exclusion
Right.
question, because yes, if recklessness is an occurrence, then we go, to their exclusion, the pollution exclusion, which we say it's not determinative because at a minimum, there are 2 of the 12 AIG policies that admittedly by AIG do not have pollution exclusions that would apply to this particular case. And therefore, in our view, those 2 policies, both of which have a duty to defend, would still have to defend the climate lawsuits. Now, AIG has argued that, well, those 2 policies were issued in the 1980s, 86 and 87, and therefore, because there's no property damage alleged in the underlying suits in those years, you can't trigger those policies, and therefore, those policies will not be implicated in terms of a duty to defend. And Judge Otake suggested that, although in suggesting that, she basically undermined her own position because she said that there were...
Counsel, aren't what you're talking about, isn't that just going to be another issue for Judge Otake? And we're just here to answer the 2 questions.
No, well, with regard to the second question, and Judge Otake said that in her order certifying the questions, that you can reformulate the questions, certainly, but you're right in the sense that whether you decide to answer that question is a function of whether it's determinative or not. And we say that it's not. We say that there are certainly allegations that we can point to in the underlying complaints that suggest the possibility of damage taking place in the 1980s. There are specific provisions of the underlying complaints that we've pointed to, and that would trigger those policy years, which would trigger their duty to defend, and they could not rely on a pollution exclusion with respect to those policies. And so if this court were to determine that, the second issue is not one that they have to decide because of that, then it would go back, obviously, to the federal district court to make a specific finding with regard to that issue one way or
Well,
another.
but I mean, the second question was certified to us. I think she had language in there apparently.
Yes.
So, I mean, it seems like that's just something that she will ultimately decide later. And that by certifying these two questions to us, she's simply seeking answers to matters of law.
Right, and obviously this court is certainly perfectly capable of providing an answer to the question, but we retain our position that it's not determinative because of those two policies that don't have applicable pollution exclusions.
What does, right, our rule says that the statute is the rule is a little bit more restrictive than the statute, perhaps? Does the statute have the determinative of the cause language in terms of certification?
I don't know the answer.
Our rule says that we only answer questions that are determinative of the cause. And that's why I'm asking whether question 2 would be determinative of the cause.
Right, and when we said in our briefs, we pointed to specific allegations in the underlying climate lawsuits that indicated, for example, that in Honolulu, they've suffered sea level rises since the 1960s. That certainly would encompass the 1980s. And there are other allegations about damage that certainly could have taken place in the 1980s. That it is the case that given the standard for duty to defend, which is there any possibility of coverage, no matter how remote, stated by the allegations of the complaint, that you can trigger the duty to defend. That's why we say that it's not determinative. But if the court decides that they want to answer that question, obviously.
If the issue then, if we answer yes to 1 and yes to 2, and the issue remains as to whether or not, based on the complaint, whether the occurrence, whether the 86 policy would provide a duty to defend, do we need to answer that question too?
No, I think that that's really presented.
Is that a question of fact or a question of law?
Well, we're looking just at the allegations of the complaint. And so this is a duty to defend case. We're not talking about the duty to indemnify. There's no liability yet to indemnify. We're just talking about the duty to defend. And we're saying that if you want to make a decision as to determination of, is this a determinative question, you have to look at those two policies. But if you were to say yes and yes, then we would still go back to the district court and say, well, they still have a duty to defend with regard to those two policies because there are allegations in the complaint. Even though you say apparently there's no property damage alleged during those years, there are certainly allegations in the underlying complaints that suggest the possibility of property damage taking place in those years, which would trigger the duty to defend. And so we would have that, debate in the federal district.
Would you have a debate? I mean, if we held that the allegations of the complaint are sufficient to raise a duty to defend, that's not excluded by this exclusion or not precluded by this exclusion, wouldn't that be the end of?
That's the end of the duty to defend question. If you, that would be a yes and a no. I was addressing the question of if you answer yes and yes. So we're obviously requesting that your answers be yes and no, that the pollution exclusion does not preclude a duty to defend these underlying climate lawsuits.
Well, I was saying if we don't even get to the exclusion because the 86 and 87 allegations in the complaint are sufficient to raise or to seek coverage or to raise the possibility of coverage, and we don't even reach the exclusion, right? So that's kind of your position. The 86, the complaints allege that there is harm that was caused in 86 and 87, and as long as there's enough, those allegations are specific enough in our view, according to you, if I understand your position correctly, there's coverage under those policies because there's no exclusion for pollution, right? Or
right. Well, obvious, yes. If this court were to find that the allegations in the underlying climate lawsuits were sufficient to raise the possibility of a duty to defend under those two policies that have no applicable pollution exclusions, we would argue that to the federal district court, yes, that issue is decided, they have a duty to defend, and that's the end of it. They will, of course, argue that, you know, that there's no damage alleged in the 1980s, and it's only alleged in the 2000s, you know, when the later policies are in play. And that's the argument that we've had, you know, going into this case. But certainly with regard to our position, we think that there's damage that's alleged in all of the policy periods from 84 to 2010. And secondly, of course, we say that the pollution exclusion does not apply in this case to a product liability allegation, which is what the plaintiffs have pled. They pled.
Let me ask you that. You know, gasoline is ALOHA's product. It causes damage when used as intended. That's how I understand your product's liability argument to go. So you're arguing that it's reasonably, you reasonably expect coverage because it's a product liability action. But are you saying that if you sell your product that is inherently, a product that's inherently polluting and dangerous, that you reasonably expect coverage for selling that harmful product?
What we're saying is these policies were issued in 1984 to 2010. Those pollution exclusions, which were drafted and inserted in the policies in the 1980s, even the total pollution exclusion came in like in 1985 and 86. And at the time, nobody would have said that certainly not our client, ALOHA Petroleum, would have said that we believe we're selling a polluting product. The question of whether greenhouse gas emissions are air pollutants, as you know, has been debated over a long period of time. And it wasn't even until 2007 when the EPA was basically compelled to regulate by virtue of the US Supreme Court's decision in Mass versus EPA. So at the time those pollution exclusions were drafted and were inserted into the policies, we certainly did not believe we were selling a polluting product. We still don't think we're selling a polluting product. But certainly if you look at it at the time that the policies were entered into, which is when you're supposed to look at contract interpretation of provisions, when the parties entered into the contract, there's no debate that products liabilities were excluded from the notion of a pollution exclusion. We put forth in our briefs the whole history of these pollution exclusions, which were basically.
What did you think the exclusion applied to versus your product then at that time?
The pollution exclusions in those policies applied to liability for cleanup of environmental contamination. They were
gas spills?
Pardon me?
Like gas spills?
Well, possibly if there were an underground storage tank of gasoline that was leaking, that could be a situation. The cleanup of environmental contamination was on the minds of the insurance industry when CERCLA was passed, around 1980. And they said, we don't want to pay for our policyholders' liability to clean up environmental contamination that may be imposed by law. And so they came out with, what they now call the total pollution exclusion. And that's what and they specifically said when they marketed those exclusions that they don't apply to products liability, and they were never intended to apply to products liability.
Did the reasonable expectation change over time in the 2000s when this greenhouse gases became more common knowledge?
I don't think so. I mean, the last policy is in 2010, which is just shortly after the Massachusetts versus EPA decision. And I should say, with regard to that decision, which of course AIG likes to focus on, that was determining whether greenhouse gases were an air pollutant under the Clean Air Act of 1970, which had an incredibly broad definition of what an air pollutant is. Whereas in our case, we're talking about, are greenhouse gases, carbon dioxide, is that a pollutant under the pollution exclusion in the AIG policies written in the 1980s for purposes talking about cleaning up of environmental contamination? And exclusions, as you know, under rules of policy interpretation are to be very narrowly construed. And so I think even in 2010, when the last policy was sold, nobody would have anticipated that greenhouse gas or the emissions from the combustion of fossil fuels was an air pollutant. Carbon dioxide, was obviously already abundant in the atmosphere, and adding more carbon
You're
dioxide.
saying nobody would have thought of this even as of 2010 or even before that?
Our client, understanding that the pollution exclusion was marketed for cleanup of environmental contamination, which is not anything that's in the underlying climate lawsuits. And secondly, again, when they marketed the pollution exclusions, they said it doesn't apply to products liability. And so, yes, our reasonable expectations were that the pollution exclusion had to do with what it was represented when it was submitted to all of the insurance regulators, which is we're not going to pay for liability to clean up environmental contamination. But that's not what these underlying climate lawsuits are about. Nobody's asking us to, suck
What
back
about
in
their-
all the carbon dioxide.
What about their plain language argument? They say they're gaseous, or irritants or contaminants, they're vapor, and they also result in heating, so they could be viewed as thermal pollution as well. What's your response? I understand you have,
Okay,
arguments relating to the context, and that's important, but what about the plain language?
sure, Mr. Chief Justice, that's a great question, and I'll answer it that we even went on the plain language, because if you boil down those definitions in the pollutant in their policies, it either has to be an irritant or a contaminant, okay? And an irritant, by definition, is something that causes bodily injury, okay? And nobody's alleging in the underlying climate lawsuits bodily injury. Or now you look at contaminant. Is it a contaminant? Well, what does contaminant mean as defined both in dictionaries and case law? It's something that makes, through mixture, something else impure. Nobody is alleging that by adding carbon dioxide to the atmosphere, you're making the atmosphere impure. The atmosphere is already filled with carbon dioxide. What's happening is that there's more carbon dioxide than otherwise would have been. That carbon dioxide, whenever it goes up to the outer limits of the atmosphere, has the effect of absorbing sunlight rather than reflecting it. But it's not making the atmosphere impure or unclean, which is the definition of a contaminant. And so we think on the plain language, they don't prevail either, given,
What about your
on the
theory of
definitions.
traditional environmental pollution? Do they prevail or not on that?
Do they, well,
there's the argument that coming from their side that they win, it seems, both on plain language or if you take it from the perspective of traditional environmental pollution,
Oh, okay.
which I believe is something you're advocating.
right, and we say this is not traditional environmental pollution. The traditional environmental pollution that these pollution exclusions were written to address is liability for cleanup of contamination of, the soil, the groundwater, surface water, or the air. There is no allegation in the underlying complaints seeking to have us clean up the atmosphere, to absorb the carbon dioxide that has been emitted. That is what, when we say traditional environmental contamination or traditional environmental pollution, that is what we are talking about in terms of a cleanup responsibility, which is not the subject of our case. Our case, as alleged, are allegations of product liability failure to warn. That is not a situation where anybody is asking us to clean up traditional environmental contamination. or
Mr.
pollution.
Sylvester.
Oh, I'm so sorry. Go ahead,
Oh,
Justice.
thank you. So, lots of questions about question 2. Let's go back to question 1, if we could, for just a moment. And I just want to make sure I understand your argument. You earlier said no conflict between Tri-S and the Krang
Yes.
line of cases. And I think what I understood you to say it's because of the allegations in the particular complaints. Is that what is that the basis of your argument?
Well, that's part of it. What I'm saying is if you look at the cases that they rely on, Kerrang, Brooks, Blanco, macadamia nut, those are cases where either A, there's criminal activity that was alleged, in the case of Brooks being an accomplice to a rape, in Blanco and in Kerrang, firing a gun at somebody, and the court said either you had a subjective intent to injure somebody or that the act and the resulting harm are so direct and inextricably intertwined that we will infer an intent to injure another as a matter of law. And with regard to the macadamia nut and some other cases, those are breach of contract cases, which nobody would seriously allege are occurrences under a liability policy. So In our case, there's no allegation of an intent to injure the plaintiffs, the city or county of Honolulu, or the Board of Water Supply, or the county of Maui. That was the same situation in Tri-S, and that's how you understand both sets of cases. They say, well, Tri-S, we're arguing that you have to implicitly overrule Brooks and Blanco and Kerrang. No, you don't. You have to understand and clarify what those cases were about. Those were intent to injure cases.
So essentially, what I'm hearing you say is the intent or the expected conduct goes to the action. Whether you're anticipating the injury is is the difference.
The difference, they're arguing, as long as you engage in any intentional act like selling gasoline, if there's some foreseeable harm,
Right.
then you can't have an accident and you can't have an occurrence. Well, that's negligence. I mean, they would, under their position, you wouldn't even get coverage for negligence. But what I'm saying is, no, the intentional act that they were talking about in Kerrang and Brooks and Blanco is an intent to injure another. And that's what we don't have in our underlying cases. And that was not also present in Tri-S. And that is how those two sets of cases are consistent with each other.
Do we use an objective or subjective standard for determining what is practically certain?
Well, it's a subjective standard for purposes of determining, expectation or intent. I mean, in Kerrang and Brooks and Blanco, even if there was no subjective intent to, I only intended to frighten them, I didn't intend to kill them. The court has said that because you were intending to injure them in one form or another, the fact is that the fact that the injury slightly differed from what you were intending doesn't take you out of an intent to injure, and it doesn't make it an accident or an occurrence. I see that my time is up for now. Unless there's anything else, I'll come back on.
Reserve the rest of your time then
Yes,
for your rebuttal.
okay.
Thank you. Mr. Ginos.
Good morning, and may it please the court. Christine Chinos, and along with Karen Naborakawa, we are here on behalf of the appellees, the AIG insurers. This case is not about reckless driving. This case is not about the normal legal use of a product. This court last August had opportunity to hear argument from a lawyer representing ALOHA and the other gas companies, and in the court's decision, it made clear what the case was about. It noted, and I apologize, I had to borrow glasses today, so it might take me a moment to read, but it said that ALOHA and the other defendants knew about the dangers of using their fossil fuel products and the impact they had on Hawaii's and the Earth's climate, but nevertheless used commercial deception to promote the consumption of those products, engaged in a sophisticated disinformation campaign, and promoted their products through misleading advertisements and by funding climate change denialist organizations. And in essence, the court said, ALOHA is alleged to have misled Hawaii consumers and the rest of the world about the dangers of using its products in a profligate manner, all of which exacerbated the impacts of climate change. That, under any measure, is not an accident for insurance purposes. It is not about harm that happened fortuitously. And how do we know that? We talked a lot about Brooks and Blanco. My colleague talked about Brooks and Blanco. Those were cases in which this court specifically said, while it was intentional conduct, it was not an intent to injure. In fact, in Brooks and in Blanco, the claims that were being considered for insurance coverage were negligence claims. In Kerrang, this court told us that the teaching of those cases wasn't that there are certain types of intentional conduct for which the reasonably foreseeable test is applied. It told us the teaching was if we start with intentional conduct, not an intent to injure, but volitional conduct. The rifle was fired. There's no doubt about that. It wasn't cocked and ready to go, a bump was hit, and it accidentally discharged. If we start with intentional conduct, and then we go, Justice Ganoza, to the mindset with which that conduct was carried out, as long as the harm was reasonably foreseeable, this court told us its teachings was that is not an accident for insurance purposes. Here with ALOHA, we know that all of their conduct, as determined by the district court, was intentional, deliberate commercial deception, advertising campaigns that were misleading, hiring denialist organizations. We know that the lowest mental state with which that intentional conduct was carried out was recklessness. The district court examining the full record told us that when it certified the question. We know that recklessness under Hawaii law absolutely requires that harm be reasonably foreseeable. What the statute says is that the person carrying out the conduct does it consciously disregards a substantial and unjustifiable risk that its conduct will cause harm. That is what it was determined is alleged here ALOHA did. So here, because recklessness by its very nature is conduct carried out with harm that is intentional conduct, knowing that the harm is reasonably foreseeable, Kerrang applies and ALOHA's conduct is not an accident.
What's your response to the argument that that's so sweeping that by negligence is reasonably foreseeable risk? So we're going to have an incredibly narrow scope of coverage under a wide range of policies across our state.
So Chief Justice, I think it is an overstatement. It is what policyholders do from time to time to try to ensure that rules that this court has already put forward aren't applied. Negligence is solely a caption of a case. This court in Dairy Road Partners told us to forget about labels. It was concerned about bootstrapping and to look at the nature of the allegations. If the conduct is intentional and it was carried out recklessly, which means there was a conscious disregard for a substantial and unjustifiable risk of harm, then even if they call that negligence, there is no coverage. In a case like Brooks or Blanco, that was applied to counts called negligence. It didn't matter because the court found it was intentional conduct carried out with an expectation, reasonably foreseeable harm.
But this court talked about expected injuries or injuries that were practically certain. Under your definition of reasonable foreseeability, I mean, negligent claims, when would there ever be coverage?
Well, for example, Your Honor, in the case of Tri-S, when the negligence was resulting from a non-intentional conduct, non-volitional conduct, there the insurer argued that all of the conduct carried out by Mr. Taft was intentional. The court specifically disagreed and said that while some of it was certainly alleged to be intentional, it is possible that Tri-S and Mr. Taft can be found liable for non-intentional conduct. Under this court's Kerrang test, that would be deemed an occurrence. So the starting point, Justice Devins, is absolutely what the conduct was. What was the nature of the act? If we start with intentional acts, volitional, you pulled the trigger firing at the car, having no intent to injure anybody, then it can be an occurrence as it was in Tri-S. What Tri-S actually held was it was a covered occurrence. That's an important distinction. Because to be a covered occurrence, you have to get by the exclusions to coverage.
Isn't practically certain akin to intentional, intending the harm?
It has to be something less, Your Honor, or else the exclusion that was being considered in Tri-S wouldn't be expected or intended. If we assume that intended was meant, it was written in, expected must be something less. And so for the exclusion that exists in the Tri-S policy, that was a separate section of the policy, coverage exclusions. It wasn't the insuring agreement requirement for occurrence. The test is practically certain. This court told us that, but that was an exclusion case. In fact, in footnote 8 of the court's decision, when it discussed, and this is why, Your Honors, there is no conflict between the two cases, unless respectfully the answer is yes, as ALOHA suggests, because we would then render the phrase expected or the exclusion, expected or intended injury superfluous. If you could get by occurrence.
Unless expected means practically certain.
Well, on that one, Your Honor,
It'd be harmonious at that point, wouldn't it?
So first of all, I would argue, and I think, and I don't want to argue against this court's Tri-S holding, but if you have a conscious disregard of a substantial and unjustifiable risk that harm would follow, if you engage in commercial deception to sell a ton of your product, knowing that the atmosphere is being polluted, I would say it is expected injury, but expected practically certain test is relevant to the exclusion, not to the initial question in the insuring agreement that this court dealt with in Kerrang. And it's an important distinction. If it applied to occurrence, Your Honor, then if you got to the point where it was expected, practically certain, and therefore there's no occurrence, why would you ever need to go to the exclusion to determine again whether it was expected? So if we're going to do what we're told to do with insurance policies, like all contracts, is give meaning to the entirety, occurrence must mean something different.
Why isn't this sort of like Tri-S, and that there are allegations that could be taken that the harm was all but intended, and other allegations that could suggest that there was a reckless disregard that the harm would occur? In other words, it could be said Mr. Taft was reckless as to whether his employee would be electrocuted, and ALOHA was reckless as to whether the environment would be heated up.
So
There's a mix. In other words, can you look at this complaint and say that there's a mix of allegations about the effect or about the outcome that range from recklessness to intent? You know, they knew it would happen, or they were reckless about whether it would happen. That's what I took Judge Otake to be saying, is that there are allegations of recklessness. What do you think?
So two responses to your question, Mr. Chief Justice. One is, I do think the determination of what the allegations in the complaint allege is for the district court. And then for the Ninth Circuit after that, if we have to go there. So with respect to this court, if the court believes that there are questions about how the complaints should be interpreted, it should probably at this stage not take the certified question. But the certified question, perhaps better written to match what is going on in ALOHA, is if a party carries out intentional conduct and does so with a mindset, the least culpable mindset, Judge Otake said, of recklessness, can that be an accident? So in this case, she has already determined we are only talking about intentional, forget about mindset for a moment, but volitional, deliberate, intentional conduct. As this court said, commercial deception, deliberate misleading advertising campaigns that made false statements about the use of the products, trying to undercut climate change science. Those are deliberate tests. In that, we then go to what was the mindset. She said the lowest possible mindset from her reading of the complaints was recklessness. Under Kerrang, the answer would be that's not an accident. I think the judge in her, Judge Otake,
Not a what?
under her would not be an accident for insurance purposes. Under Kerrang, Brooks, Blanco, and Hawaiian Holiday. Under Tri-S, again, that would not be an accident. The distinction with the facts of Tri-S is that Mr. Taft convinced the court there, and the Supreme Court, this court, agreed that it was both intentional and non-intentional conduct for which he faced liability. So if he engaged in non-intentional conduct, that was the finding. With a mindset of recklessness, you get by occurrence, you go to the question of whether it's a covered occurrence, and then it's whether or not the injury was expected and therefore practically certain.
I'm still struggling. Aren't there allegations here that could be interpreted at, you know, at some times perhaps as time went on, their actions were intentional. They knew at some point, and again, I'm not saying this is the truth, that climate change could be the result of selling their product, but perhaps earlier on, they were reckless as to those risks in 1988, 1990, 1991 or two. As long as there are allegations that they were reckless as to what the result would be of their intentional conduct of selling the product, isn't there coverage under Tri-S? And why not? If you think, I assume you're going to say no, so why not?
If I said no, Your Honor, I'd have to sit down. If I said, no, there would not be. So first, we would start with the court's Hawaiian Holiday, Kerrang, Brooks Blanco test, the reasonable foreseeable results test. And the answer would be intentional conduct carried out recklessly would be no coverage. If there was a chance here that some of the
intentional conduct carried out recklessly, isn't it intentional conduct with reckless disregard as to the effect?
Yes, but one is looking at the act, intentional versus, for example,
they marketed the product, right?
Yes.
And then the question, their state of mind as to what the effect of that would be allegedly reckless.
Right, so for example here, they did not accidentally engage in any of the alleged advertising, right? That was always intentional. They weren't part of a group that they didn't know was doing such advertising. Everything they did here was allegedly with intent. Once we go there, we're different than Tri-S. Good, because Tri-S made a finding against what the insurer argued, that what was possible was some of the things Mr. Taft did may have been non-intentional. Once they determined and they pivoted and they said it was non-intentional, they said there was an occurrence. We don't disagree under this court's Kerrang test because there was no intentional, volitional, deliberate conduct. Now they went to state of mind. If it was reasonably foreseeable and that was it, it wouldn't meet, this court said, the expected portion of the expected or intended injury exclusion. If it was reckless, it still wouldn't meet that. It would fall slightly below expected. Respectfully, I disagree with that, but that is the test. If it's reckless, it's less, but then the exclusion wouldn't apply. So Tri-S, footnote 8 makes this clear when it cites to only cases from out of state, including the Indiana Court of Appeals, is an expected or intended injury case, not an occurrence case. Can't get to there, can't get to the exclusion until it finds an occurrence.
ALOHA argues in its brief that, previously, most CGL policies, at least, the definition of an occurrence included, situations where harm was not expected or intended. In other words, that expected and intended language was somehow within the definition of occurrence. And then somehow in the 80s, it split into, being put into a separate exclusion provision. Do you agree with that? And what's the effect of that argument?
We do agree, Justice Ganosi. It started, there's an organization called the ISO
Yes.
that helps insurers draft policy language. In 1986, the neither expected nor intended language came outside of the definition of occurrence in the insuring agreement, went to an exclusion.
Right.
Even when it was inside, it was 2 requirements. Occurrence, accident dealt with what's the nature of your act, and neither expected nor intended dealt with what was your mindset when you were about the injury that might result. What was your mindset about the act? It didn't change. And in fact, in Brooks, it was the old version. In Blanco, it was the new version, separate exclusion. This court made no distinction. And even ALOHA in its papers has agreed that that distinction is not relevant for purposes of the certified questions before this court.
Well, I mean, if it's within the definition of occurrence, or if you treat it like that, then whatever is an occurrence is everything up to, isn't it? Up to and unless it is an expected harm.
Yes, but even when it's inside the definition, if an accident is only not there when injury is expected, then accident has no independent meaning. And we are told by this court, Dairy Road Partners, for example, that we should read policies like contracts to give meaning to all of the phrases. When it's excluded, for example, Justice Ganosi, if we believe that the occurrence test is satisfied unless it's expected, unless it's injury is practically certain, we would never have reason to use the expected or intended injury exclusion. There must be a difference, or else we're not reading the policy the way we're told to.
Well, isn't it, alternatively, isn't it potentially just there as the floor or the roof, however you want to look at it? I mean, is the demarcating line?
Some courts have said it's there as an example when it was inside the definition. Some courts have said it's there solely as an example of what is clearly not an accident. Again, I think if we do that, we don't give meaning to both sets of words.
Well, is it also a possibility that the reason why you had that exclusion is to shift the burden of proof to the insurer with respect to that piece?
That certainly occurs on the mindset piece. And the question, by the way, on expected or intended is it's an objective standard, a reasonable insured standard, so that we wouldn't then have to prove what was in your mind. And perhaps people that have carefree attitudes don't expect injury. People that study what they do a little more carefully do. It is objective. And the standard does switch when it's outside. The reason ISO said it moved it outside of the definition is because courts conflated the two. They looked at them, some courts looked at them as the same. one sort of describing the other, and the drafters of the language said, no, there are two separate requirements. The focus point of the first occurrence or accident is just the nature of my conduct. The focus of the second, whether it's inside insuring agreement or a separate exclusion, is the mindset I had when I carried out that conduct in terms of whether it may result in injury. So the way that Tri-S, this court's decision in Tri-S, which they say supplanted the prior decisions, it did not. And the Kerrang test meet is with the first part of the two-part test. What was the nature of the conduct? In the first four cases, this court made clear it was volitional acts. Watching an assault happen and making a decision not to do something, firing a rifle, breaching an agreement to help farm macadamia nuts. In the latter case, Taft, based on his affidavit, convinced the court it was possible he would be found liable for non-intentional.
I'm sorry.
Sure.
No, I wanted to turn your attention to the pollution exclusion and ask if you could address what I understand ALOHA's argument to be, that this is the ordinary and intended use of their product. They sell gasoline and it combusts, and the products of that combustion go into the air. How could it not be covered? That's what I understand one of their arguments to be. What's your response to that?
So that their argument has been that there are versions of the pollution exclusion that are limited to, for example, on-premises pollution, or that exclude products, PCOH, from the pollution. I mean, they have a version in the earlier years that's limited to pollution on premises. So here, of course, it's going to be off premises. It's going to be from the use of their product. Again, I think here we should be clear of what they're facing liability for, and we have to assume that for purposes of insurance analysis is certainly not the normal legal use of their product. But even so, what they claim, and this is from, this argument started between the parties, I think, from a case called Nautilus against Hawk, is the concept that it only covers traditional environmental pollution. I think it's important to realize how that is defined in that case. It's not the CERCLA case, or we buried a tank only. That would be easy. We could say buried storage tanks are not covered. Instead, the insurers broadened the provision to have a very general definition of what can be covered, and in doing so, covered pollutants that are discharged, dispersed, released. Why is that traditional environmental? The Nautilus versus Hawk case made a distinction between, for example, a heater in your home that malfunctions and one time lets out carbon monoxide, and there's pollution in the air, there's poisoning that results. Versus the incessant use in an industrial setting that constantly releases large amounts of carbon monoxide in that hypothetical that then pollutes. That's the definition of traditional environmental pollution. Here, as we argued at the district court, if traditional environmental pollution is baked into the definition, even though the words don't say it, we have traditional environmental pollution. It's alleged that over the last 50 years, they knowingly pumped out tons and tons of fuel and put information out that was designed to increase rather than decrease the use, so that it got to a point where the atmosphere was so clogged, so contaminated with greenhouse gases, that it changed the Earth's climate.
So he has a different definition of traditional environmental pollution. He has all this history about CERCLA being passed in the 80s. The insurance companies didn't want to be responsible for funding Superfund cleanups, and these exclusions should all be viewed through that lens, which the definition you just suggested is, well, carbon monoxide goes out into the air, so any widely dispersed pollutant is traditional pollution. So how are we supposed to decide who's right in that battle of dueling interpretations of what this means, and what should our touchstone be in coming to a good conclusion or correct conclusion?
I think the starting point, and perhaps the touchstone, Chief Justice, has to be the words of the policy. The court told us in Dairy Road, in Del Monte, a decision from this court that they cited for the reasonable expectations doctrine, is that the way we get to the insured's reasonable expectations is to look at the words that were used. And so before we get to traditional environmental pollution, I think we would have to agree that the words used apply. And I don't really think there's a huge disagreement about this part of that, which is if you look at the exclusion, what's not covered is property damage covered in whole or in part by the discharge, release, dispersal, seepage of pollutants. If we took the word pollutants out, put greenhouse gases in, I think it would be pretty simple, it would apply. When you put pollutants in and we look at gaseous or thermal irritants or contaminants with examples like smoke, soot, and vapor, the words clearly apply to greenhouse gases. If there's any doubt about reasonable expectations, again, ALOHA was before this court, both in papers and orally in August, arguing about how pollution that they're alleged to have contributed to should be regulated. What they are doing is alleged to be polluting the atmosphere with greenhouse gases. If, Mr. Chief Justice, we should change now what those words mean by reading in, as they allege, this concept of traditional environmental, it would do damage to the words. It would go away from the rule of figure out reasonable expectations from the words themselves. For example, some of what they cite, I think they miscite, what are articles written by policyholder lawyers. So if they show you 10 of those and I show you 10 written by my colleagues, what are you to do? Again, return to the words. I think the clear words here apply.
Well, Mr. Sylvester argued it's neither a contaminant nor an irritant. What's your response to that argument?
His argument that it's not an irritant is the argument that irritant applies solely to bodily injury. I think he cites for that primarily a district court case from the Northern District of Texas that did not say that. It simply ruled that in that case, where there was no bodily injury alleged, the alleged pollutant was not an irritant. Irritant is anything that goes out that has a negative physical effect in a dictionary definition. We believe greenhouse gases fit that. The definition, though, is irritant or contaminant. From the allegations that we must take true from the underlying climate change lawsuits, I think it's hard to imagine anything that contaminates more than the profligate use of carbon fuels that result in greenhouse gases in the atmosphere so great at such a level. This isn't me exhaling carbon dioxide. This isn't other methane releases. This is about the profligate use of a product that puts so much greenhouse gas, alleged knowingly, into the atmosphere, contaminates the atmosphere, that the Earth's climate changes.
Let me ask you if I may that. You said look at the words, and the Eighth Circuit did look at the words, a similar pollution exclusion, and they said it was ambiguous. And as you know, the Hawaii courts, we resolved those ambiguities in favor of the insured. How do you address that case, the Sargent case?
On ambiguity, Your Honor, I think, again, it's an issue for the district court. If this, one of the hard parts we get on duty to defend is if their argument were taken to its extreme, insurers, anytime two judges could disagree on the meaning of something, would always have a duty to defend. We would never have an opportunity on duty to defend to get guidance from the court. So I think in that instance, I think we should decide if the words apply. If at the end of the day, they want to say there's an ambiguity to the district court and the district court says, well, then no matter what, I'm going to find there's a duty to defend. Judge Otake can do that. The only ambiguity they have raised in their papers below is traditional environmental pollution, adding that requirement in to the requirement. And again, that ambiguity doesn't matter because this meets that definition. It may not meet what they're claiming now is their view of it, but it meets, if you look at if you look at the Hawk case, Nautilus v. Hawk, it meets what is described there as traditional environmental pollution, which isn't a one-off instance. It's something that happens gradually over time and essentially changes the makeup of the thing it's contaminating, air, sea, or land. Here it was the atmosphere, air, and it had a negative impact. And it did, again, no one disputes, it is alleged, cause in whole or in part property damage in the counties, right? In the form more severe weather, more frequent severe storms, cause more intense heat, cause events that cause property damage. If you trace that back, it goes to greenhouse gases. If you trace it back to liability, it goes, as this court said, to allegations of commercial deception. So the district court asked two questions after extensive briefing and extensive argument from the parties. It asked essentially whether Tri-S supplanted this court's decisions in Kerrang. The answer is no. The answer to the first question respectfully should be no. If you say yes, it would mean that commercial deception and sophisticated disinformation campaigns are mere fortuitous events. We know they're not. On the pollution exclusion, if we need to get there, and we don't, if you answer the first question, no, there's no need to answer the second. If you get to the second, we think the plain meaning of the words of the policy, which this court has told us control, establish that, like they have said numerous times, greenhouse gases are pollutants, and they fit within the clear terms of the pollution exclusion.
I don't know if I heard you correctly. Are you saying we don't have to decide if it's ambiguous or not? That's for the district court to decide?
Yes, Your Honor, I think the certified question is simply whether greenhouse gases satisfy the definition. If the court ultimately decides it needs more information, for example, it wants a study done or something like that, I think it would get sent back for the record to be developed. But I don't think this court is being asked whether or not there's a duty to defend here. That is for the district court to decide.
What's your take on the issue about the 86 and 87 policies not having a pollution exclusion?
So they have a pollution exclusion. They have one that we agree doesn't apply to just the premises. I'm sorry.
Imprecise in my phrasing, yes.
So
It doesn't apply here.
So on that, again, the court said apparently those aren't in play because although there was greenhouse gas pollution in the 80s, it was alleged in the complaints that it wasn't before the turn of the century that the atmosphere was contaminated enough to start changing the weather. And it was years after that that property damage resulted from more severe weather. Those policies are not in play. In this court's decision in Lima, it noted that when it's possible that the court, once this court sends it back to the district court, will rule in favor of one party or the other based on this court's guidance, that is sufficiently determinative of the cause to give this court the authority to decide that. So those policies the district court have decided aren't going to be part of this, or else I don't believe the district court, and we should take it at its word, would have sent the question up. If the district court said, I might ultimately rule that those policies are in play that have a pollution exclusion that everybody says doesn't apply, the court couldn't have also said that this court's answer to question 2 was determinative of the cause. So I think we should
try one more time. I'm trying to
sure. I
join you on your journey into Judge Otake's mind. So
well, so the Judge Otake, when she sent the court question 2 up to this court,
right,
noted specifically that she believed it was determinative of the cause.
Right. Even though, because she thought there were allegations, again, it seemed a little conflicting because there are 2 policies where there's an exclusion that concededly doesn't apply, and yet she seemed to think that there were allegations sufficient to trigger coverage under those policies. What do you make of that? That's what
on that. I respectfully disagree. I don't think she thought there were. So the one of the arguments we made below, we made 4 arguments in the district court. One of the requirements of liability policies is the trigger. The trigger here is property damage that occurred. They face liability for property damage that occurred during the policy period. So if they face liability for commercial deception that led to worse climate change that caused property damage, we need to see property damage in the mid-80s resulting from those activities. She found that could be the case because she said if there was apparently no property damage caused by ALOHA's actions, at least as alleged, in the mid-80s. So I think she thinks the first 6 policies, all of the policies pre-1990 are out. If she didn't believe that, then question 2 would not be determinative of the cause.
Gotcha.
So I think we have to assume that the district court believe that. And so when we go back, if this court answers question 2, yes, it will end the case as to the remainder of the policies.
And yeah, if you want to wrap up very briefly, and Mr. Sylvester, I'll give you additional time as well. So if you could just...
I appreciate that. I've finished my statements. I'm certainly happy to answer any further questions the court has.
All right. No, thank you very much.
Thank you very much,
Appreciate it,
Chief
Mr.
Justice. Thank you.
Mr. Sylvester, if you need an additional 2 minutes, you can have it.
Thank you, Mr. Chief Justice. I'd like to address a few of the points that Mr. St. Janice has made. And again, if you take the position that they are asserting. That is, any intentional act is the first part of getting out of an occurrence. And then the second part is if there's any reasonable foreseeable harm that occurs, then you can't have an accident, you can't have an occurrence. Then you've basically wiped out liability insurance coverage in the state of Hawaii, because I would submit that almost any liability causing conduct is going to be argued by AIG to be an intentional act, whether you're intentionally driving at an excessive rate of speed, whether you intentionally put a flammable liquid out in the hot sun and it turns out that, you know, it explodes and causes a fire, or in the case of Tri-S, whether you intentionally decide that you're not going to enhance safety factors to prevent electrocutions of machine workers who are working near high power lines. Those are all can be characterized as intentional acts. And because all of them could give rise to a claim that, well, it was foreseeable, reasonably foreseeable, that the harm could result from that, therefore they would say it's not an accident, it's not an occurrence, you don't get liability coverage. That is not the law of Hawaii, and it's certainly not the law around the country, because even reckless conduct with a conscious disregard for the probable harm, that's what's being alleged in the worst punitive damage claim paragraphs of the underlying complaint. They say that, the defendants have a conscious disregard for the probable dangerous consequences of their conduct. They are not saying that we intended to injure the plaintiffs, and that distinguishes what is an occurrence from what is not an occurrence. And that is how you look at all of the case law from this Supreme Court, from Kerrang to Brooks to Blanco to Macadamia Nut and Tri-S. In all of those cases, other than Tri-S, the intent to injure another party was either clear or manifest, or the conduct was of a such nature, if I shoot a gun at somebody trying to frighten them, that is deemed, whether you hit them or you just miss them, that's deemed enough to be an intent to injure, that it can't be an accident or an occurrence. The notion that any intentional act already, checks off the first of the two blocks for getting out of coverage would be an incredible reduction of liability coverage for policyholders all around the islands. And mark my words, AIG would use that to try to deny coverage for all sorts of claims that nobody in their right mind would think were not covered under a general liability policy.
I think we certainly I understand your argument that there's a difference between the awareness of the risk of a harm and the awareness of certain harm. Can you address their point about the pollution exclusion and the plain language? And I also had asked you a question about the traditional environmental pollution that counsel answered in his view. So if you can address that now.
Well, with regard to the pollution exclusion, I should say, first of all, Judge Otake did not make any finding as to whether there was or was not property damage alleged in each of the policy periods. She said apparently there may not be, or the allegations are scant or sparse, whatever the word was that she used in her opinion, which, by the way, would allow for the possibility and therefore allow for triggering those particular policies that don't have exclusions that are applicable. But the other thing that she ruled with regard to the pollution exclusion, if you read how she gets to asking the certified question, is she says there are reasonable interpretations on both sides, and it gets to the ambiguity question. If you find that the pollution exclusion and the use of the word pollutants in the context of greenhouse gases is ambiguous, then the answer to the second question is no, because ambiguities are to be construed against the drafter. The insurance company drafted the policy language. Secondly, this is an exclusion. Again, should be interpreted even more narrowly than basic insuring agreement language. And thirdly, should be construed in the context of the time when the parties entered into the contract back in the 80s. And so I'm not sure, Justice Edens, if that answers your question or not. If not, could you please let me know and I'll try to address it specifically.
Well, I understand your argument about what she may have been serving up to us, but I guess what I'm just wondering is just a straight examination from your point on, one, the plain language, and then two, the traditional environmental pollution, because they say they went on both fronts.
Right, and of course, we think they don't win on either, but if you look at the definition of pollutants in their policy, you know, pollutants means any solid, liquid, gaseous, or thermal irritant or contaminant. And then there's including smoke, vapor, soot, and fumes. And of course, the including, whatever follows, has to be an irritant or a contaminant. Now, Mr. St. Janis got up here and said essentially, well, irritants aren't limited to bodily injury. Irritants is anything that causes harm. Well, if irritant is defined as anything that causes harm, which is, I think, essentially what he defined it, then the pollution exclusion swallows the entire coverage, because obviously you don't have a liability claim unless somebody was harmed. And if somebody was harmed, they was harmed by some active agent. And you know, regardless of what it is, you can always, in any liability circumstance, identify something that caused either physical injury to a person or property damage, damage to property. And so their definition is so broad as to what an irritant is, it can't possibly, it would lead to absurd results. And many courts have held that. So it's not an irritant. And the only other thing is a contaminant. And while they say, well, you know, you're contaminating the environment by virtue of putting more carbon dioxide into the atmosphere than otherwise was there, but how is that making it impure or making it unclean, which is the traditional definition, you know, strict policy language of contaminant. Carbon dioxide is already abundant in the atmosphere. Granted, greenhouse gases put more of it in, and it has a chain reaction effect that ultimately is alleged to cause physical property damage to the plaintiffs. But again, if one considers a contaminant to be anything that could cause harm, then the pollution exclusion can be used by AIG and the other insurers to deny almost any claim. And in fact, they've tried that all around the country. I know I litigate these cases around the country, and they, you know, their last resort to deny coverage is the pollution exclusion, because you can always find some agent that has caused the harm, and they would say, well, if it causes harm, it's a pollutant, it's a contaminant, or it's an irritant, and therefore, you know, voila, we don't have to pay.
Well, and then isn't that why to many courts to suggest that we're not going to sweep it so broadly, then adopt the traditional environmental pollution prong to this?
Yes, I mean, that's why that they say there has to be some limitation, some reasonable limitation. Otherwise, the pollution exclusion swallows the entire liability coverage. And the insurers, what they do all around the country, because I've seen it in many states, is they decide if they don't want to pay this claim, if they got nothing else, they've got the pollution exclusion.
And is your position that the traditional environmental pollution piece is just not applicable because it only relates to like Superfund types of things?
Because it only relates to liability for cleaning up environmental pollution. And that, whether it's a CERCLA or it's a state Superfund, or whether it's a private landowner who is neighboring to a property that says, hey, you know, my water well is contaminated, or you know, you've got soil contamination leaching from your property or whatever. If it has to do with liability for cleaning up environmental contamination, that's what I mean by traditional environmental.
As I've understood some courts to define traditional environmental pollution, they've said it has three aspects. One, the widespread release of a damaging substance. Two, into the environment. And three, that causes harm because of its presence in the environment. How does what the product your client sold not fit that definition?
Well, it doesn't fit, number one, because the release, dispersal, escape, they're talking about a release from containment. That's what that it means, like the leaking underground storage tank, or you know, some release from a facility. So there's not a release in the sense of we're using a product for its intended purpose. It's intended to have certain emissions that come out of the tailpipe of an automobile. So it's not released from containment. It's not intended to be contained. And in terms of causing harm, the the remedy that is sought is to eliminate the contamination that's causing the harm. That is to eliminate the PCBs in my underground water well, or to take the TCE that is in my soil and extract it and clean up the soil on my property. Those are the kinds of environmental cleanup situations that the pollution exclusions that were drafted and inserted in the 1980s and carried through were intended to apply to, and that is not a products liability situation. We're here, they sold us product liability coverage. If you look at every single one of their policies, it has specific coverage limits for products liability. That is, if we put our product out into the market and if it's intended to be used for its lawful purpose, and nonetheless it causes harm to somebody, they say they have coverage for it. Now, granted, it's under certain aggregate limits and the like, but they promise to provide coverage, and that's how these cases are alleged by the underlying plaintiffs in the climate lawsuits, and that's why the pollution exclusion should not apply.
Is that how you're distinguishing like the AES case and the Allen case, where you have the power utility and you have that sandblasting or concrete crushing companies? They're actually causing the actual emissions.
Yes, I mean,
versus
the AES case, of course, that was Virginia law, which is somewhat different, but that was a direct emitter. It was a power plant, and they were saying that it was emitting. Here, we're selling a product. They're selling us product liability coverage. And again, there's no intent to injure. The only thing that Mr. St. Janis said that we intended to do by the so-called, campaign of deception, and by the way, there are no specific allegations about ALOHA Petroleum specifically with regard to any of that. But nonetheless, what he said, and I heard him, he said, well, our intent was to try to sell more gasoline. That was our intent. Our intent was not to injure or to harm anybody. And that's what takes it out of Brooks and Blanco and Kerrang, and again, the other cases that they cite in Hawaii, if they're not, criminal activities, they're like breach of contract, breach of warranty, or, fraud, defrauding your business partner or something like that. And again, those cases, there is an intent to injure a third party. That's not what's alleged in our case.
Mr. Sylvester, I think I've given you quite a bit extra time. I appreciate it. Anything further for the court at this time? Or is that complete?
Nothing. Thank you for your time and attention.
Very well. Thank you to both of our attorneys. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'o malalo ia mai ne kea aha ho'o kolo kolo ki ke hano hano. This Honorable Supreme Court of the State of Hawaii is now recessed.